it's Myra and Erica, and we're Flesner
Wentzel.
Wentzel. We're
Okay.
back, okay? Back again.
Shane's back.
No, Flesner Wentzel's back.
No, we're always back.
Okay, we're always back. We're always here. Don't have to get ready if you stay ready.
God, we're always here. Anyway, so we wanted to do this video because we have a lot of cases with court, and with the coronavirus going around and doing whatever's happening, there was a court order that the Supreme Court of Missouri just issued, so we wanted to talk about that.
Bam! Court order.
We wanted to let everybody know how that could or couldn't affect you. If you have something that, happens to you, can you get any kind of help? So anyway, so FW, we're open.
For business.
Yes, because the courts are open.
Technically.
Yes, they are open. What they've done is suspended in-person hearings. So we'll talk more about the order in a bit, but most people are going to be asking, why are the courts still open? And so I guess we should start why we're open.
Yeah, okay.
So we're open because courts are still open.
People need stuff done.
Yes.
To get ready for when the courts decide to have hearings again.
And the courts are open because justice don't wait for no damn virus.
Right.
I had to say that.
She had to say that. It's actually written
It
in
is.
her line.
No
So justice don't wait for no damn virus. Anyway.
So what Flesner Wentzel is doing to help, our staff is working from home. I'm more productive when I'm here, so.
Yeah, I can't get shit done at home, so
No.
I'm here.
So for those of you who are our clients and are watching this, it might slow things down a little bit because a lot of people aren't physically here in the office, but we're working on that, so just kind of bear with us. Everything will get handled. Nothing, deadlines aren't going to be missed, anything like that. It's just a matter of getting it all together. The second thing is we want to relay information out to you guys because we get a lot of questions asked about what's going on and how this will impact their case or anything in the future that they're kind of concerned about. And then, not to be morbid or anything like that, but we've been kind of talking a lot more about estate planning. Erica is doing a series about estate planning because people in general avoid estate planning all the time. Like, nobody wants to talk about it. And yet, when something does happen, it's worse to not have it taken care of than to just
Get your act together now.
Yeah, get it together. This is the time to work things out. I mean, even we're kind of a hot mess sometimes, and we both have
At least our healthcare power of
Healthcare,
attorney and
yeah.
our financial power of attorney.
yeah. So
We're halfway there.
exactly. So look for those. Erica's doing lives on Facebook with that, and so because it'll give you really good advice as to how to handle certain things. What the court is doing to help. So on the 16th,
March 16th, 2020, in the year of our Lord, Anno Domini, an order was issued
by the Supreme Court of Missouri. So that's important. Basically what they've done is they suspended in-person hearings from the 17th of March until April 3rd. So basically,
which is a Friday,
yeah.
so really April 6th.
Yeah, so basically April 6th would be the time that we could go back to court in theory. Now, what does that mean? Because people are like, well, if court's suspended, they might as well be closed. That's not accurate. So we kind of wanted to go through the order to discuss every piece of it, to explain how that impacts you, how that doesn't impact you, kind of what's going on with there. So we have our notes here because we had to break it down. Because in the law, words matter. So
number one, every state has its own order. So this is specific to Missouri. So if you're watching this to see how coronavirus will affect your Maryland case, I'm sorry, but you need to be a better Googler.
I'm sure a lot of them are similar, but I'm not
Here's
sure.
something.
Yeah.
Right. So this beast, why does it just suspend and not close the courts? That is because the courts can't close, because what if you got arrested and then you couldn't get out on bail until April 6th? That's bullshit, right? So you need to be able to get things that are done on an emergency basis still done.
Yeah, so the family court, juvenile court, municipal courts, and probate, all in-person hearings are suspended. Now, there are exceptions because we're lawyers and that's what we do.
Right, so the answer is always, is my court date canceled? It depends.
Always.
It depends is the secret.
It depends.
It depends.
So anything that's necessary to protect your constitutional rights, especially for criminal defendants and juveniles, that's open.
Or people that have mental health issues and are being committed.
Yep,
Those
that's
people
open
as well.
Orders of protection.
So if there's a domestic violence situation, you can still go and request an order of protection. If you're being stalked, you can still go and request an order of protection. I'm not sure about this, but what I've heard is a lot of the courts are going to use their discretion to say that a hearing can't be held in 10 days and give you an ex parte, which is an order that you get the first time you show up that's longer, like 30 days to get us through the suspension, so that you just go apply for it. If you get it, then you don't come back to court until after the suspension is over.
Right, so you can still go to the physical court and do what you need to do to get done. Emergency child custody orders. So what does that mean? If you call one of us or message us, that we will determine whether or not we think the court will think that's an emergency. So, hey, someone's going to take my kid out of the state and not come back and disappear. Probably an emergency.
I want to change Tuesday night in my schedule for Wednesday night. Not an emergency.
Right.
Somebody's leaving my kid home alone every night without supervision because they started working overnights and the kid is 7. Probably an emergency. So it's really just going to have to be a fact-by-fact situation, and we're going to have to be honest with you because the court is not going to be amused if we try to set something that's not really an emergency. So there are certainly things that are important, like changing court or schedule dates, things like that, that are not going to be an emergency basis that the court's going to deal with them right now because the court would rather keep everybody alive, which is a responsible choice.
Yeah, no, I thought that was good that they did that. So then we have emergency guardianships or conservatorships, so anything that would fall into that category, it's something that needs to be done. Let's say you have someone that needs a conservatorship because they're just blowing through their money or someone's taking advantage of them, that would probably be something that would qualify under that. Anything that would be related to the coronavirus, public health emergencies, that still falls under the court jurisdiction.
Technically, if you know who gave you the coronavirus and you want to sue them, you can still have a court date. Isn't that magical? I don't know how we would get to that point in our lives, but
we'd still have to allow people to get tested first of all. So.
Right, so it'd be a mess.
Oral argument regarding time-sensitive matters. So anything, I believe, in the Court of Appeals and the Supreme Court oral argument is canceled, unless it's something that has to be handled like within in that time frame. And then as the Chief Judge of the Missouri Supreme Court decides to make an exception for. And then also every circuit court in the state of Missouri can also determine, they have a presiding judge and they can also determine whether or not there are exceptions that fall under, not under what they've already listed.
And if you do have one of those emergency hearings that they're going to have, you are not supposed to just bring your friends to support you. The only people you're allowed to bring are the attorneys on the case, the parties on the case, so you, if it's your case, and any witnesses that are needed. So if you are in a new relationship and your significant other needs to come to be able to testify, they saw your old significant other punch your child in the face or something terrible like that, fine. But otherwise, you can't bring your significant other just for moral support anymore because they're trying to limit the number of people in the courthouse.
Right. And then most of the circuit court orders that I've seen have suspended all jury trials and having the jurors come in. So generally only juries that were already started, like the jury trials.
So if they started Monday, kept it going, but
right. Also the courts are encouraged to use any type of technology, so that would be email, teleconferencing, video conferencing, so to limit court appearances. So even if you could have a hearing for a temporary restraining order, let's say, they're going to they encourage the circuits to actually to use the technology to still not have you appear.
Correct.
Now, I think you'd have to appear just for other purposes.
Depends on what's up, yeah. And then the last thing that's in the order is that if you have any of the COVID-19 symptoms, you should not show up to the courthouse, no matter what. So even if you were having an emergency child custody hearing, they would continue yours specifically because they don't want you in the building ruining everything for everybody else. So don't do that. The long and short of this is, how does it affect you guys? So if you have a case and there's something that's not emergency, it's going to have to be handled after April 6th. Does that mean that we can't file it now? Does that mean we can't get ourselves a place in line? No, it doesn't. Which means that if there's something going on, even if it's not an emergency, you do need to reach out to your attorney and get this handled. Because I would anticipate the week that this all goes away, April 6th, it's going to be a madhouse in the courthouse because everything's going to be stacked up. And those dates may fill up. Certain judges have a limited number of spots, and once they're gone, and you might not be able to reach for 2 or 3 weeks after that if you're not proactive. So certainly do communicate with your attorney about anything that is going on.
And also, I mean, the court order, like, there's still other stuff about, like, it doesn't affect deadlines. So
Correct.
if you have a deadline, let's say you got discovery 10 days ago. Well, you still only have 20 days to file your discovery responses under the 30-day rule. So you still have to do things to keep your case progressing. If you have motions that need to be filed, you still need to get them filed because, there are certain rules with when people need to be notified. You have to set that hearing. And like Erica was saying, if you wait till the last minute or you set it, trying to set it a week after this goes away, then you're going to be waiting in line. So just think this basically is for 3 weeks that we're not having in-person hearings. That's a long time. A lot of judges have motion dates like every day during the week. So imagine how many of those cases are all being pushed 3 weeks down the road. So that's something to keep in mind. The courts will have to help you if you do represent yourself, so that's important to know. Go to the courthouse if you need something, talk to the clerk, see what's kind of going on. Because again, the deadlines
still matter. Have to answer your stuff, have to turn things in. If you have something that has a deadline, like for instance, doing the parenting class on a new case that requires an in-person appearance somewhere and you don't feel safe going to a parenting class, you should let your attorney know so they can file a motion to waive the parenting class or file a motion to extend the time. Things like discovery are a big deal. And
or like, what if you just get served? That's the whole thing too. Like if you just, you've been served, or like a week ago you got served, then that still cuts into your answer period.
Correct. So if you just got served, you got 30 days to answer, you still need to answer within those 30 days. And it might be hard to find lawyers taking new client appointments during this time. So certainly make sure we'll talk to you, don't worry about it. We do most of our initial stuff on the phone anyway. We're doing video conferencing. So there's a lot of things that people can do to kind of accommodate basically getting the business of the law still done and getting the immediate needs accomplished. And especially if you have an immediate need, you need to let your attorney know immediately. It's amazing. Okay.
Yeah.
Anything else? Wash your hands. Stop buying the toilet paper.
Yeah, it was mostly like the court is trying to, like in the order itself, it was like, we have to preserve our constitutional rights, blah, 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 like.
Yeah, so we are still here, we are still fighting the good fight, but we're fighting it from our offices for the next 3 weeks except for emergencies. So if you got an emergency, we're kind of stir crazy.
No, we're not.
No, it's actually nice. No, I mean, I can wear my pajamas in here, it'd be great.
But there is you are limited. You are limited as to what you can and can't do depending on what it is.
Yep.
Okay, bye.
And the teleprompter's not present?
No teleprompter. I wish.
We need to get huge.
Yeah.
Huge. So we can have a teleprompter.
That's right.
Oh, excuse me. That's my St. Patrick's Day. Just coming through.
Alright.
Right.
Okay. Hold on. We should probably change something.
Hi, I'm Erica.
I didn't mean it like that. I meant like, we should just be like, hey guys, Myra and Erica, we're back.
Hey guys, it's Myra and Erica.
I'm not touching my hair. Hold on. Okay, go.